Hi, I'm Sam Goldstein. I'm the Director of Legal Affairs for B'nai B'rith Canada and the National Director of the David Matas Law Society. I want to welcome everyone. Thank you for joining us today for our program on the law of armed conflict, focusing on the Israel-Hamas war. Today's event is hosted by the Matas Law Society, Canada's only hub for Jewish legal professionals and law students. The Matas Law Society, named in honor of the esteemed David Matas, stands as a beacon for legal excellence and human rights advocacy. David Matas, a distinguished lawyer and human rights activist, has been a crucial figure in B'nai B'rith for over 3 decades, contributing significantly to some of the organization's most important cases. As senior legal counsel, Mr. Matas exemplifies the spirit and vision that guide the Matas Law Society. There is no better way to protect group rights than by protecting individual rights. I'm now going to hand the matter over to my associate at B'nai B'rith, Ilit Aharonson, and I just ask if we could all put ourselves on mute. And as just a quick note, I'm very pleased you're all here. I came across Mr. Wheatley's article in the USA Today, and as soon as I read it, I knew that this was the person that we needed to get to talk to us all. So, Ilit, I hand it over to you.
Hi, good day. Today we are privileged to have Captain Thomas N. Wheatley as our speaker. As an assistant professor in the Department of Law at the United States Military Academy at West Point, New York, he brings a wealth of experience in constitutional and military law. As we navigate through the complexities of the law of armed conflict in the context of the Israel-Hamas war, Captain Wheatley's expertise and insight promise to enrich our understanding of these crucial legal issues. Thank you for joining us today as we embark on this insightful journey into the legal dimensions of armed conflict. I'm honored to hand the Zoom stage over now to Captain Wheatley.
Thank you, Ilit. My sincere thanks to both Matas Law Society and B'nai B'rith Canada for inviting me to talk on this very important topic. And of course, thank you for your kind introduction. I hope I live up to it. First, just as a housekeeping matter, I apologize. I've got a nice glare behind me, but it wouldn't be a proper Zoom call unless you had a little bit of technical difficulties. But I ask that you bear with me here. So before we begin, I'm, of course, obligated to issue the standard disclaimer that comes with these sorts of things. And that is everything I say today, I am saying in my personal capacity, not as an Army officer or agent of the United States government. So the views that I express are my own and do not necessarily reflect the views of the United States Military Academy, the United States Army, the Department of Defense, or any part of the United States government. So with that, formalities out of the way, let's go ahead and dive in. I would be remiss indeed if I did not first offer my heartfelt condolences and prayers to all those in the Jewish community in attendance, as well as those not in attendance. The world has just witnessed the largest massacre of Jews since the Holocaust, with approximately 1,400 Jews murdered in their homes and neighborhoods and hundreds more taken hostage. Throughout my lifetime, both as a Christian and as an American, I have always been blessedly naive about the true nature of anti-Semitism, and I believe that it had largely been relegated to the fringe and extremes of society, sort of the sphere of the skinheads, right? And I always thought that the sheer human cost wrought by the Holocaust would ensure it would stay there. Today, I now see much more clearly the threat is here and it's now. Indeed, the nightmare of October 7th did not end when the sun set that day. In the days and weeks following, before the death toll from Hamas's pogrom had even been calculated, we saw how the narrative advanced by radical anti-Semites and Hamas sympathizers began to take shape. They would tell us, incredibly, that Israel, not Hamas, was to blame for the events of October 7th. They would turn morality itself upside down, telling us that Israel's obligation to defend itself against brute savagery itself was wrong. Eventually, they would swarm every major Western city, cheering Hamas and announcing their genocidal intentions in unequivocal terms. That is, to eradicate Israel and the Jewish people, quote, from the river to the sea, end quote. The civilized world can't afford to ignore this threat. It is existential in nature, not only to Israel, but to the West as a whole. At the moment, Israel is doing the heavy lifting in countering this threat. And as I speak, the IDF is making its way through Gaza and destroying Hamas block by block. This is good and necessary. But there remains the important work of rebutting and debunking the stream of lies and deceits endemic to the anti-Semites' cause. It's here where scholars, journalists, lawyers, really actually anyone with functioning eyes, ears, and a conscience can and must act to safeguard the truth. Which brings me to today's topic. As Israel launched its military response to Hamas' October 7th attacks, Israel's critics wasted no time in smearing the Israeli cause. Among other things, this included making unsupported allegations that Israel had violated international humanitarian law, or as I call it in my profession, the law of armed conflict or the law of war. These allegations typically rested on outlandish constructions of international law, often accompanied by scant factual support and skewed reasoning. This fake body of international law is dangerous, and not just for Israel's immediate sake, but for my own country's sake. Left unchecked, it will compromise the United States' ability to fight and win its future wars. So in the days following October 7th, I set out to correct the public record, hoping to reach just enough people to ideally form a bulwark of truth against this barrage of lies. It's in that spirit I am so pleased to share with you some of the work I've done to date. As an overview of today's talk, I will proceed first by outlining the critiques of Israel's approach that are commonly offered by some commentators and journalists, as well as others in the international community. I'll then identify and apply relevant American interpretation of the law of armed conflict using primarily DoD, that is Department of Defense materials, but also by citing historical examples from American military campaigns as support. And then from there, I'll offer a broader legal conclusion as to what's happening in Gaza. So given this most recent conflict between Israel and Hamas has elements of both international and non-international armed conflict, the pertinent laws of both to which Israel has chosen to bind itself will apply. Specifically, these laws include the 1949 Geneva Conventions, all four of them, Common Articles 2 and 3 of the same, the principles of LOAC, and customary international law. Although Israel is not a party to Additional Protocol 1 or Additional Protocol 2, those 1977 protocols to the Geneva Conventions, I'll consider both when advantageous for greater context or understanding. So there are four main critiques that have been leveled against Israel in the course of its military response to the events of October 7th. First, critics have decried Israel's what they call a complete siege of Gaza prior to its ground invasion, describing it as unlawful collective punishment. Second, critics have lambasted Israel for what they describe as a forcible evacuation of civilians from northern Gaza into the south. Third, Israel's critics have focused on Israel's use of white phosphorus, namely concerning its use in military operations along Lebanon's southern border between 10 and 16 October, but also in Gaza as well. And fourth and finally, I'll address Israel's broader bombing campaign that was prior to the invasion and respond to the charges that Israel is violating the principles of the law of armed conflict. So I'll take each in turn. If you want more information about what I'm going to talk about today, including like some of my sources, research background, I would direct you to a paper I published recently for George Mason University's Center for the Middle East and International Law. There you can get a little more details in these respects. So I think you'll find that what I say today will mirror what's in that paper broadly. So let's jump right in. Let's talk first about the siege. One of the foremost criticisms of Israel's response to the attacks of October 7th concerned Israel's siege of the Gaza Strip, with some referring to the siege as an unlawful form of collective punishment. So, although the effects of a siege on non-combatants and civilians can be devastating, siege is not prohibited under the law of war. According to the DoD's interpretation, inherent to the authority to lay siege is the authority to exercise control over civilians. That includes stopping, searching, diverting traffic. And they're also able to forbid all communications and access between the besieged place and the outside. We saw a lot of commentary about limitations on Wi-Fi availability in Gaza. That speaks to that as well. Although encouraged to do so, a commander is not required under the Geneva Conventions to arrange for the removal of wounded, sick, infirm, and aged persons, children, and maternity cases, or for the passage of ministers, medical personnel, and medical equipment on their way to such areas. Commanders are likewise encouraged to allow the passage of what they call relief consignments, that is to say food, medicine, clothing, but no such requirement exists if the commander laying siege believes such consignments either may be diverted from their destination, may not be effectively controlled, or if it incurs a definite advantage to the forces of the enemy, and that is their military forces or their economic capability. And so while forces laying siege may not refuse to allow civilians to flee a besieged area, there's no requirement on the part of besieging forces to guarantee civilians' ability to flee. Nor is there a requirement to permit civilians to flee behind the besieging forces' line, right? There's nothing that says that people in northern Gaza have a right to cross the border into southern Israel, or for that matter, to provide for refugees or displaced persons. So when it comes to reducing incidental harm to civilians, the primary party responsible for that is actually the besieged force. Specifically, the besieged force should mark protected buildings to indicate their protected status to enemy forces. That includes hospitals, schools, other civilian centers. They should also concentrate the wounded and sick and civilians in areas remote from military objectives. It's their job to sequester these people away from the battlefield. I'll throw in a quick word about starvation because that's gotten a little bit of press. To be clear, starvation directed at civilians by the besieging force is prohibited. However, starvation directed at enemy forces, even where incidental starvation may result for civilians, is lawful if conducted in accordance with the principles of distinction and proportionality, which we'll talk a little bit more later in the lecture. Of course, Additional Protocol 1 generally prohibits the destruction of what it describes as objects indispensable to the survival of the enemy civilian population, and that includes things like foodstuffs, agriculture areas for the production of foodstuffs, crops, livestock, drinking water installations, and supplies for irrigation works, if it's done for the purpose of denying civilians or the adverse party the ability to use them. Yet even Protocol 1 has a special carve-out for what they call imperative military necessity when a party to the conflict is engaged, this is key, in territorial defense. So understanding how this legal scheme applies to Israel requires consideration of how it's been applied in the past. So given the counterinsurgency paradigm of the global war on terror in the last 2 decades, siege warfare is admittedly less common than it was, say, 200 years ago. But that said, it nonetheless remains a viable means of waging war, especially when an adversary takes up refuge in an urban center such as Gaza. So, for example, the United States, alongside the Iraqi army and its multinational coalition as part of Operation Inherent Resolve, they engaged in siege warfare as recently as 2017 against the Islamic State in the city of Mosul. And during that siege, the death toll, which included civilians, reportedly reached as high as 11,000 people, and roughly 3/4 of the city was destroyed. So despite these losses, siege warfare was credited as instrumental in delivering a victory to the Iraqi army and the multinational coalition, with one scholar even going so far as to observe that so long as the positional battle of attrition's layered urban defense continues, that is to say, defense in an urban environment in a layered fashion, so too will its counterpoint, the siege. So turning to Israel's situation specifically, although Israel has laid siege to the Gaza Strip, it has not done so out of retribution or punishment, but for a military advantage in pursuit of its adversary's surrender or defeat. Israel has neither directed its siege at civilians nor prohibited civilians from fleeing the area. In fact, it has urged civilians to leave the locality. Moreover, Israel is under no obligation under the law of war to facilitate the passage of humanitarian assistance, as we're seeing frequent calls for in the media. And that includes those that might benefit civilians remaining in the Gaza Strip. That is doubly so true, given the risk that such assistance will be intercepted by Hamas. Despite this, Israel has agreed to permit food, water, and medicine for civilian use to pass into the Gaza Strip from Egypt. It's under no obligation to do so, but yet it has chosen to do so, perhaps even against its military strategic interests. And for similar reasons, Israel is under no obligation to agree to a ceasefire or a humanitarian pause, particularly if the risk is too great that such a break in the hostilities will advantage Hamas. Yet even here, as we've seen in the last week or so, Israel has gone above what is required of it by law, allowing for brief humanitarian pauses and even establishing temporary corridors through which civilians can flee the battlefield and find safety. So to the extent that Israel's siege has resulted in incidental harm to civilians, the harm has been worsened profoundly by Hamas's refusal to satisfy its minimum obligations. We have Israel on the one side vastly exceeding what's required of it. On the other side, we have Hamas's failure to meet even the minimal requirements under international law. And those requirements include, as we discussed earlier, marking protected buildings to indicate their protected status to the enemy force, and to concentrate the wounded and sick and civilians away from military objectives. Indeed, it seems Hamas has done the opposite, intentionally concentrating its military forces near hospitals and discouraging civilians from fleeing to safety. In real time, we are seeing IDF liberate hospitals from Hamas's grip, and I expect we'll find out more in the coming days as we learn more about the Al-Shifa hospital. So for these reasons, Israel has certainly acted lawfully concerning its siege in Gaza. Turning to the forcible transfer of civilians, or as it's been billed, critics are referring to the October 13th order for civilians in northern Gaza to evacuate. Some commentators, including some at the United Nations, unfortunately, have claimed that Israel's complete siege of Gaza, combined with the evacuation order, could amount to what they call a forcible transfer of civilians in violation of international law. But the prohibition against forcible transfers in international law comes from Article 49 of the Fourth Geneva Convention of 1949, which states that, quote, individual or mass forcible transportations, as well as deportations of protected persons from occupied territory to the territory of the occupying power or to that of any other country, occupied or not, are prohibited regardless of their motive. However, there is an exception. Total or partial evacuations of an area are permissible if performed for the security of the population or for imperative military reasons. An occupying power that conducts such a transfer or evacuation has a few obligations if they choose to do it. Specifically, the occupying power must ensure to the greatest practical extent that the proper accommodation is provided to receive the protected persons, and two, that evacuations or transfers are effected with satisfactory conditions of hygiene, health, safety, and nutrition. And then finally, that family members are not separated. So applying this set of rules to Israel's case, the threshold question is, was Israel, prior to October 7th and in the days following October 7th, is Israel an occupying power within the meaning of Article 49? To be sure, some in the international community regard Israel as an occupier of the Gaza Strip as a result of Israel's continued control of Gaza's territorial waters and airspace. This position is untenable, however. The customary definition of occupation under Article 42 of the Fourth Hague Convention states that a territory occupied when it is occupied when it is actually placed under the authority of a hostile army. The Hague Convention further limits the definition of occupation to apply to only the territory where such authority has been established and can be exercised. So following Israel's unilateral disengagement from the Gaza Strip in 2005, many in the international community, including many international law scholars, military professionals, and foreign policy experts, have concluded that Israel's occupation of the Gaza Strip ended when it unilaterally withdrew. For its part, the United States does not recognize Israel as an occupier of the Gaza Strip. Moreover, prior to its recent ground invasion, Israel had no troops permanently stationed in Gaza and had no meaningful control over life in Gaza. Its orders therein were completely unenforceable. It's hard to say that you're an occupier if you can't even enforce the orders and edicts that you're issuing. Excuse me. So nor has Israel used force or even the threat of force, even as it now conducts its ground invasion, to remove citizens of Gaza from their homes. Instead, Israel has merely warned them of the coming danger and encouraged them to leave temporarily for their safety. That the effects of a lawful siege might also motivate some civilians to seek safe haven elsewhere hardly amounts to a forcible transfer, as some have argued. If that weren't the case, then any instrumentality of war detestable enough to drive civilians from their homes could easily form the basis of an illegal forcible transfer. Clearly, such an expansive definition of forcible transfer has no workable basis in international law. On the other hand, even if Israel were to be considered an occupying power engaged in a temporary evacuation of Gaza's civilians, it does not follow that Israel is required to provide for the accommodation and basic human needs of evacuees. Article 49 imposes such an obligation on the occupying power only insofar as it is practicable. It's difficult to say the least, right, to think that such accommodations are practical in Israel's case, as even the mere presence of Israeli troops in the Gaza Strip is liable to result in, quote, numerous casualties among Palestinian civilians, as well as Israeli soldiers, and potentially triggering a dramatic escalation of hostilities. That does not seem to suggest to me practicability. If you want an additional sanity check on this point, history readily provides one. To see just how dissimilar Israel's actions are from that which was contemplated by Article 49's authors, one need only revisit the haunting reason for Article 49's existence as it's captured in the 1958 commentary to the Fourth Geneva Convention, which is, quote, "There is doubtless no need to give an account here of the painful recollections called forth by the deportations of the Second World War, for they are still present in everyone's memory. It will suffice to mention that millions of human beings were torn from their homes, separated from their families, and deported from their country, usually under inhumane conditions. These mass transfers took place for the greatest possible variety of reasons, mainly as a consequence of the formation of a forced labor service. The thought of the physical and mental suffering endured by these displaced persons, among whom there were a great many women, children, old people, and sick, can only lead to the thankfulness for which the prohibition embodied in this paragraph, which is intended to forbid such hateful practices for all time," end quote. That is a far cry from tearing women, children, old people, and the sick from their homes to work to death in forced labor camps. Israel's actions are a far cry from that. They're far more appropriately characterized as a warning to civilians of an imminent attack, as is required by long-standing customary international law.
Do you have the information for our flight? Okay.
Indeed, Israel may not be trying to repeat its own recent history. After the 2008-2009 conflict in Gaza, a report published after a United Nations fact-finding mission criticized Israel for, among other things, not providing sufficient warning to civilians in Gaza. So certainly in American history, such warnings are par for the course. In the Korean War, for example, the United Nations Command broadcasted warnings to the people of North Korea. And these warnings included explicit calls for civilians to leave areas near military targets. In 1999, during the conflict in the Federal Republic of Yugoslavia, Amnesty International criticized NATO for what it described as a consistent failure to give effective warnings to civilians. In Afghanistan, at the beginning of the global war on terror, NATO routinely issued general warnings to the civilian population prior to the attack. In fact, some NATO aircraft would fly close to targets or shoot warning rounds to move civilians away from a potential target. Meanwhile, in Iraq, NATO forces dropped approximately 31.8 million leaflets in total, advising Iraqi civilians of pending attacks and urging them to move to safety. Thus, whether you view Israel as an occupying power or not, Israel has acted lawfully. Its calls for a temporary evacuation of northern Gaza amount to warnings to a civilian population prior to an imminent attack, as is required by customary international law. They do not rise to the level of an unlawful, forcible transfer, as Israel's critics claim. Yet even if Israel was an occupying power, Article 49 provides an explicit pardon for the temporary evacuation of civilians for the security of the population or imperative military reasons, and an exception to the requirement of providing for the accommodation of basic human needs of evacuees, if doing so is impractical for the occupying power. So, we'll move now to the discussion of the principles of the law of armed conflict talking about white phosphorus and Israel's larger bombardment campaign in Gaza. So another criticism Israel leveled at Israel is its use of white phosphorus. This has gotten outsized attention in the media. And Israel's critics claim that it has violated the law of war principles of distinction, humanity, and proportionality. I'll consider each of these, white phosphorus and the broader bombing campaign, separately in turn. So first, white phosphorus. So the DoD Law of War Manual describes white phosphorus as a munition that contains fragments of white phosphorus intended primarily for marking or illuminating a target or masking friendly force movement by creating smoke. Importantly, white phosphorus is not included in the DoD's definition of an incendiary weapon, but is instead considered a weapon with, quote, incidental incendiary effects. And for this reason, white phosphorus is not subject to the DoD Law of War Manual's restrictions on the use of incendiary weapons, including the general prohibition on using incendiary weapons within a concentration of civilians under Protocol 3 of the Convention on Certain Conventional Weapons. Furthermore, let us remove all doubt on this point, which is often missed in discussions of law of armed conflict. White phosphorus may be used as an anti-personnel weapon. I'll say it again, white phosphorus may be used as an anti-personnel weapon. And let us remove even further doubt on yet another important point. While there are restrictions under certain treaty obligations on the use of incendiary weapons in civilian centers, first off, Israel is not a party to those treaties, and there is no categorical prohibition under international law on the use of white phosphorus in war. There is no categorical prohibition on the use of white phosphorus under international law in war. But of course, we have to set limitations on that, right? That, like any use of white phosphorus or any action taken in war, for that matter, the use has to comply with the principles of the law of armed conflict, and that is military necessity, humanity, distinction, and proportionality. For those unfamiliar with these principles, I'll provide sort of a brief description of each here. So, military necessity is defined as the principle that justifies the use of all measures needed to defeat the enemy as quickly and efficiently as possible that are not prohibited by the law of war. Military necessity justifies wartime violence and destruction, but also justifies certain incidental harms that inevitably stem from such violence and destruction. One sec. Humanity is defined as the principle that forbids the infliction of suffering, injury, or destruction unnecessary to accomplish a legitimate military purpose. It is the sort of logical inverse of military necessity, acting as a limitation on the violence and destruction broadly justified by military necessity. Proportionality is the principle that even where one is justified in acting, one must not act in a way that is unreasonable or excessive. This principle reflects the use in bello prohibition on excessive incidental harm and creates a duty in belligerents to take feasible precautions for the protection of civilians and other protected persons and objects. And finally, we get to distinction, and distinction is the principle that obliges parties to a conflict to distinguish principally between the armed forces and the civilian population and between unprotected and protected objects. So under the American DoD's interpretation, this principle imposes on belligerents two sets of duties. The first is the duty to discriminate, which is in combat to discriminate between what is an enemy and what is a civilian. And then also it creates a duty on all parties to distinguish themselves in terms of their uniforms and use of objects, so as to not, say, turn a civilian object into a target or to try to blend in some perfidious manner with the civilian population. It also obliges parties to a conflict to refrain from the misuse of civilians and other protected persons and objects to shield their own military objectives. So we can look to recent uses of white phosphorus in American military history. Again, we return to Mosul. The United States there led a coalition that used white phosphorus as recent as 2017 in the fight to liberate the city from the Islamic State. And they used it there actually to help evacuate civilians from the city. Prior to that, the United States used white phosphorus, which American soldiers at the time had nicknamed Willie Pete, was used in 2011 in Afghanistan to quote, set fire to any Taliban rockets at the firing positions, causing them to explode and preventing them from being fired on the American outposts, end quote. Before that, in 2004, the United States used white phosphorus as extensively in the battle, in the Second Battle of Fallujah, rather, where it was credited as an effective and versatile munition when employed against the insurgents via the shake and bake method, is what it was called. That's essentially when they use it offensively against entrenched insurgent positions. So in Israel's case, there is no evidence Israel's use of white phosphorus in Gaza is anything but lawful. No evidence has been put forward showing Israel targeted civilians or used white phosphorus indiscriminately. Indeed, there's no evidence Israel used munition against personnel whatsoever, though they could have under U.S. rules. Indeed, Israel's critics seem to operate under the mistaken belief that, one, because Israel used white phosphorus, two, in an urban environment, and three, civilians were subsequently harmed, a war crime or violation of the law of war has occurred per se. And this is flagrantly wrong. As I noted earlier, Israel is not a party to Protocol 3 of the 1980 Convention on Certain Conventional Weapons, which prohibits, quote, in all circumstances, making any military objective located within the concentration of civilians the object of attack by incendiary weapons. Nor does any likewise prohibition exist in customary international law. So with no treaty obligation or legal custom prohibiting the use of white phosphorus in urban centers, the only way Israel could be in violation of the law of armed conflict is if Israel violated one of the principles of the law of armed conflict, i.e. proportionality, distinction, or humanity. Yet here too, Israel's critics come up short. White phosphorus is an effective tool in war, used among other reasons to provide concealment and mark lawful military targets. On this point, I admit I'm a little bit disadvantaged. I don't know Israel's internal military processes for observing the principles of LOAC, and I suspect few outside the IDF do. But just because the military advantage Israel gained by using white phosphorus has not been made public, it does not mean such an advantage did not exist or was not proportional to the harm suffered, nor does it imbue Israel's actions with the illicit purpose of causing needless suffering or mean that Israel failed to take feasible precautions to protect civilians. For these reasons, I can't conclude that the use of white phosphorus in Israel's case was unlawful, as the critics claim. After the bombing campaign more generally, some observers have accused Israel of violating the law of armed conflict in its broader campaign in the northern portion of Gaza Strip. Notably, this includes recent airstrikes that killed civilians in residential and refugee areas. I've already discussed before principles of the law of armed conflict, so I won't waste your time restating them here. But I will say the DoD Law of War Manual offers additional instruction worth consideration on the responsibility borne by the parties subject to attack to reduce the harm, risk of harm to protected persons and objects. So in all conflicts, the law says parties to a conflict should take, quote, feasible precautions to reduce the risk of harm to protected persons and objects from the effects of enemy attacks. Parties subject to attack, when appropriate, should avoid placing military objectives, such as the armed forces, in urban or other densely populated areas, taking particular care to ensure civilian hospitals are situated as far as possible from military objectives. They should also seek the voluntary removal of civilians from the vicinity of military objectives through warnings. The last of these might include establishing safety hospital or neutralized zones that civilians have safe places to move forward, or even concluding local agreements for the removal of civilians from besieged and encircled areas. And these are obligations that fall onto Hamas. These are Hamas's duties. Do this. Predictably, the use of human shield is, of course, unlawful, and although attackers must take feasible precautions to minimize the risk of harm to human shields, the party that employs human shields in an attempt to shield military objectives from attack assumes responsibility for their injury. The person using the human shield is the one who assumes responsibility for their injury. Now, Hamas is the de facto governing body of the Gaza Strip. That's language taken directly from the Director of National Intelligence's website. And it has been since 2007. Under these rules of distinction and proportionality, it has a duty, Hamas has a duty to reduce the risk of harm to civilians from an adversary's armed attack. Yet at every turn, it has refused to do so. Where Hamas was required to avoid placing military objectives in densely populated areas, it has exploited the civilian population as human shields. One Hamas leader even went so far as to declare, quote, "We need the blood of women, children, and the elderly of Gaza so as to awaken our revolutionary spirit," end quote. And where areas for medical care for civilians should be clearly distinguished and separated from the vicinity of military objectives, Hamas has established a military command and control center under Al-Shifa Hospital, the largest hospital in the Gaza Strip, and used civilian ambulances to transport weapons and militants. This is perfidy. And where civilians should be encouraged to flee the vicinity of lawful military targets, Hamas has demanded civilians remain in place amid the fighting and crossfire in northern Gaza. Hamas even reportedly went so far as to execute civilians caught trying to escape. These failures are not just important evidence to substantiate Hamas's failure to comply with the law of armed conflict. They are directly relevant to determining whether Israel violated the law of armed conflict, namely the principle of proportionality. The DoD Law of War Manual states that when the attacking forces causes harm that are the responsibility of the defending force to its use of voluntary human shields or due to the employment of civilian personnel in or around military objectives, the responsibility of the defending force is a factor that may be considered in determining whether such harm is excessive. Hamas's use of human shields cuts in Israel's favor in terms of proportionality analysis. So in contrast to Hamas's actions and failure to follow the law of armed conflict, and just like in the white phosphorus question, there is no evidence that has been put forward that shows civilian deaths in Gaza wrought by Israeli bombs were by intentional design. To that end, not only has Israel repeatedly warned civilians to leave northern Gaza, there is no evidence that Israel has abandoned the principle of distinction in its military operations, that its bombing campaign has caused needless suffering, or that the bombing has not been proportional to the military advantages it seeks. That civilians have been incidentally harmed in the course of the war does not negate this fact, nor does Israel's decision not to publicize, likely for reasons of military necessity, its internal processes to ensure observance of the law of armed conflict. Although such secrecy admittedly puts Israel at a disadvantage, right? The world sees when Israel chooses to shoot. The world never sees when Israel chooses to not shoot. Indeed, Hamas itself seems convinced of Israel's adherence to the law of armed conflict and is keen on exploiting it. Hence, Hamas's interest in enmeshing lawful military targets among civilian populations and hospitals. Certainly, Hamas has a lot of confidence that Israel won't violate the law of armed. And as a final matter, I'll say the principle of proportionality raises an additional consideration, one where I think jus ad bellum intersects with jus in bello, as well as a commander's consideration of what you might describe as the broader imperatives of winning the war. That's certainly how the DoD Law of War Manual describes it. It's most salient. Unlike the fight, for example, to retake Mosul from the Islamic State in Operation Apparent Resolve, or the American campaign against al-Qaeda in Afghanistan following 9/11, Israel's mission is not one of nation building. It's not winning hearts and minds. It's not engaged in a Cold War era attempt at containment, nor is it engaged in peacekeeping or other forms of law enforcement through military means. Israel is not seeking unconditional peace, but an explicitly conditional, more just peace. Unconditional peace is not the goal. An explicitly conditional, more just peace is. Israel is fending off an attempt at territorial conquest from the river to the sea, as they say, as well as the violent assault on its sovereign independence. For these reasons, Israel's ground war in Gaza is less like the U.S. invasion of Iraq and more like the Allied assault on Nazi Germany in the Dune of 1944. In the hours preceding Operation Overlord, that is D-Day, General Dwight Eisenhower called for the, quote, destruction of the German war machine, the elimination of Nazi tyranny over the oppressed peoples of Europe, and security for ourselves in a free world. And he was willing to accept nothing less than full victory. By its stated terms, Israel's war following the events of October 7th is really no different than that. For peace in the Gaza Strip and the Levant more broadly, Hamas must be destroyed. Its tyranny must be eliminated. That's the strategic goal here. All questions of proportionality, therefore, must be viewed through this lens. This analytical footing, taken in conjunction with Hamas's repeated failure to follow the law of armed conflict, leaves very little doubt Israel has acted lawfully under the principles of the law of armed conflict. And so to close, we'll recap here just for a moment. So Israel's actions in response to Hamas's murderous rampage of October 7th have thus far been lawful under international law and the law of armed conflict, as interpreted by the American Department of Defense and as applied in American military operations since the Second World War. First, Israel's siege of Gaza reflects a long-standing and legitimate means of waging war, and the available evidence does not support the conclusion that Israel is engaged in quote-unquote unlawful punishment. Israel's siege of Gaza reflects, as to the allegation that Israel has forcibly transferred civilians in violation of the Fourth Geneva Convention of 1949, Israel's call for civilians to evacuate northern Gaza ahead of its bombardment and ground invasion is more in the nature of an advance warning to civilians of imminent attack, as is required by customary international law. It is not a forcible transfer of civilians. As to Israel's use of white phosphorus, there is no categorical prohibition under international law on the use of white phosphorus, and Israel is not a party to any treaty outlawing the use of white phosphorus in urban centers. Moreover, there has been no showing that Israel's use of white phosphorus in recent weeks has violated any of the principles of the law of armed conflict. And finally, as to Israel's bombing campaign generally, although Israel's bombardment has led to civilian deaths, the simple fact that civilians have been harmed in war does not mean that a war crime or a violation of international law has occurred. Particular evidence of a disregard for the principles of distinction and proportionality is necessary. Yet, as with the white phosphorus analysis, there has been no evidence put forward suggesting the design of Israel's bombing was to attack civilians or to flout the law of armed conflict. Indeed, its call for civilians to evacuate suggests the opposite. In addition, Hamas's own failure to abide by the law of armed conflict, particularly by using civilians as human shields, cuts in Israel's favor in a proportionality analysis, not against it. So for all of these reasons, I think Israel has acted lawfully so far in the prosecution of the war against Hamas. And that wraps up really what I got for you today. I'm happy to take questions.
If there are any questions, please either send them via chat or put your hand up.
You should ask a question.
Hi there. I have a question.
Yeah, go ahead.
So one of the things that I'm seeing is, one of what we see is an internationally trusted agency, the United Nations. Of course, they have UNRWA and the most number of censures against Israel of any other country in the world. And yet the world relies on them for common sense. But what they're putting out, of course, is anything but. They're directly contradicting what you've said today. And I'm curious on your perspective of the UN and how it's impacting the world's perception of all this.
Thank you for your question. So I have to reiterate, I'm speaking in my own capacity here, not on behalf of the Department of Defense, but I have grave doubts about the UN's ability to be fair and impartial in its adjudication. Anything relating to Israel or for that matter, the Jewish people. I think there's substantial components of the UN, both the General Assembly and the Security Council, that have been compromised by anti-Semitism. And I don't mean to oversimplify your question or give you too short of an answer here, but I think at bottom, that's what we're dealing with here. And that's why on questions relating to Israel and in terms of fair treatment, I don't think the UN can be trusted.
There is a question in the chat. It has been suggested that the initial attack by Hamas was primarily against civilians rather than an attempt to seize land, military objectives. Do you agree with this?
I'm sorry, can you repeat that one more time?
No problem. It has been suggested that the initial attack by Hamas was primarily against civilians rather than an attempt at seizing land, military objectives. Do you agree with that?
Well, I think they're saying that the purpose of the attack was to attack civilians and not necessarily gain territory. I think that's a difficult position to defend when their slogan is from the river to the sea, right? I think the explicit purpose is to erase the Jewish state, and whether they do that through short-term territorial gain via conventional military operation or through terrorizing Jewish civilians into fleeing their country or surrendering it, is really immaterial here. The fact of the matter is that these Hamas belligerents crossed the border into Israeli territory and began asserting control over Israeli territory. That is, in my view, that's hardly distinguishable from a territorial conquest.
Sam Goldstein would like to also ask a question.
Hi, Captain Wheatley. One of the usually when David Matas attends, he automatically gets the first question, but since he's not here, since I'm the director, I get to ask the question. So, Captain, one thing that and we thank you for what you said. Again, I immediately when I read your USA Today op-ed, I knew that you had to speak to us, but there's a movement or a slow movement from many Jewish lawyers trying to make two things. One is trying to get Hamas reported to the International Criminal Court, and whether there's any laws of international flavor that apply to, as you call them, non-combatants or belligerents. That's number one. I mean, are they completely exempt from any of this? And secondly, how can we get the international? Is there any law that would force the International Red Cross to get to see or to make claims to go see the hostages? So laws that deal with essentially terrorists, if there's anything, are they completely exempt? And secondly, any laws that the International Red Cross can enforce to go see the hostages? Maybe a pipe dream.
So I'll say never on the Red Cross visiting hostages, but I think that would be an enormously difficult task, and not the least of which reason is that there's political sensitivity surrounding I guess the culpability of the entire attack itself, right? Like if the world can't agree on who's at fault for October 7th and whether it was justified or not justified, and I'm horrified that we can't seem to agree on that in parts of the West, then it's hard to see the ICRC taking any steps that would, I guess, put itself in the limelight like that. But I could be wrong, and I hope I'm wrong. I hope the ICRC would do that. I don't know of any law that could force them. As to your first question, I'm sensing that you're asking more so about accountability and how do we punish those who have committed these atrocities. So I would be uncomfortable relying on the ICC to ever prosecute. I think a better avenue, especially considering that the attack happened on Israeli territory, would be an Israeli court set up pursuant to universal jurisdiction, very similar to the Adolf Eichmann trial of 1962. I think that has strong symbolic value, and I can't think of a legal reason why they couldn't do it, but I admit I haven't done the full length analysis yet. But I think that would be a more effective way of doing it. And the IDF is in a good position now to capture those, certainly in Gaza, to bring them to justice. Well, I guess if they're outside of Gaza, right, that didn't stop Israel in the past from bringing people to justice, right?
Mm-hmm. That's right. Thank you.
So we have Alon Polak that would like to ask a question.
Hi there, just taking myself off of mute. Captain Wheatley, thank you for your time. It was a very interesting presentation. In light of the images that Israel is slowly releasing of what they're finding at Al-Shifa Hospital, I'm wondering if there is, prior case law or interpretations of when a civilian infrastructure loses its status as civilian. So in other words, how many Kalashnikovs and how many RPGs does it take in a hospital for a hospital to stop being a hospital? Thank you.
So I admit I don't know of the bright line test, right? For it takes X number of Kalashnikovs, then we got ourselves a command center, right? But certainly under American doctrine, an object's nature is determined by its use. though, of course, a hospital that deals with it, that even enemies of the wounded is still protected. But we're not talking about treating enemies of the wounded. We're talking about a hospital being used as a command and control center for military operations. I mean, at that point in time, I think as long as you have a good faith, colorable argument that's supported by factual evidence and quality intelligence that a hospital is no longer a hospital, right? Then at that point in time, the proportionality analysis is affected in such that in a way that would, I think, point towards striking versus not striking. Recall that the attacker has to obviously always follow the principles of LOAC, but ultimately the harm, the civilian harm, when people are used as human shields, falls on those using human shields, and that makes a lot of sense, considering what incentive it would create if that were not the case.
Thank you.
Thank you. Let's go to Asad Khan. You have your hand raised.
Hi, thank you, Captain, for the talk. So, my understanding is that, and I'm by no means I'm not well read on the law of armed conflicts, but my understanding of the Fourth Geneva Convention, when it pertains to civilian protection of civilians, especially the provision of and maintenance of medical and hospital establishments, and the words that I was reading, and I would like to see your view on how either retrospectively, once evidence is found, or subject to perhaps even being open to an independent investigation of these matters. But my question really is that when the words used in the Fourth Convention talk about maintenance of hospitals and medical facilities, and also ensuring that public health and hygiene in the occupied territory are maintained, and that necessary measures are taken to combat the spread of contagious disease and epidemics. And what's coming out of the news that's being reported, I was reading the Guardian, for example, and it seems that the sewage pumps no longer have fuel, and that so consequential effects is what I'm talking about. And I understand completely the idea that Al-Shifa Hospital has been used as a base, but when it comes to ensuring transparency, what are the responsibilities of the invading force or the occupying force, whatever it would be deemed, and what would be the responsibility in permitting an investigation, and who would be an institution that can give a definitive answer that is.
I think you cut out. I think the last part of your question was cut out.
I'll just summarize that last part. That if there is going to be an assessment of the damage, and I understand that every violation of the Geneva Convention is not a war crime, it is the disproportionate or an egregious violation of the Geneva Convention is a war crime. So if that is to be considered by an independent body, what would be that independent body that can be trusted by Israel as well? And I appreciate you said that the ICC and the UN, they've made statements which make them seem like they're not impartial. So who could be impartial? Because I think at this point the world is divided in a way that we need an impartiality, right?
Certainly, yeah. So in terms of our international bodies, our international governing bodies, as I was saying earlier, I'm not sure that those bodies exist that can be trusted, and sort of like, well, in the in the United States we have the U.S. Supreme Court, right? When it issues a decision, it's the decision, it's the law of the land, and even if you don't like it, you respect it because you are bound and respect the institution, right? And certainly our Constitution. I don't know of any body on the international sphere that has that level of clout. I think if we were to investigate something, it would have to be, just off the top of my head, a coalition of countries that have a pretty clean track record of rights, a clean record of human rights respect, for example. Though I do want to I get an investigation is a good idea, I think, and I don't think anyone here would be opposed to the idea of holding those accountable where evidence did emerge, where there was a wanton disregard for the rule of law of armed conflict, where there was war crimes. But I think getting it correct is important in terms of partiality and impartiality, right? I will add I kind of sense sort of some of the thoughts behind your question there. You brought some stuff up. We should remember that the law of armed conflict is not a suicide, right? And as far as Israel's responsibility as an occupying power or not as an occupying power, kind of as I talked about earlier, though I guess if it does continue its assault on the Gaza Strip and seizes control, it will become an occupying power. Even those obligations for an occupying power, they don't apply if they're not practically executed. If that makes sense. And in terms of holding people accountable for war crimes, in the United States, commanders are judged by what's called the Rengelik rule, which is we can only judge commanders based on the information they had at the time they made the decision, not what comes to light. So any kind of accountability measure would have to reflect that standard for it to be just. Though, of course, if evidence emerged that a commander did know something and perhaps just didn't tell anybody anything, then, of course, I can't see why that person shouldn't be held accountable.
Thank you, Captain. Would you, in parting, I'll just ask, is there some place you would recommend that someone who's a lawyer, a law student, but is not aware of what the intricacies of the law of armed conflict is, where would be a good starting point for them to educate themselves? And with that, thank you so much.
Yeah, sure. So the ICRC, International Community for the Red Cross, their website is a great resource for learning kind of like the four corners of law of armed conflict, international humanitarian law, as they call it. The Lieber Institute here at West Point produces some fantastic articles about how this law is applied, though some of that is more granular in its analysis and more detailed. Outside of that, those are pretty good starting resources there. Those will show you more research.
Thank you so much.
If anybody else has more questions, please raise your hand. I know we asked in the chat, but since we're getting so many questions at once and we want to get to everybody, can you please, if anybody here has an additional question, please go ahead and raise your hand.
And so, Ilit, I will say, I think I have time for about one more because I do have a meeting with a student after this.
Perfect. So let's go to Jonah Freed.
Hi there. Thank you for speaking to us, Captain Wheatley. Could you speak to the legality of some of the IDF's conduct in the West Bank, which obviously isn't exactly connected to the ongoing invasion or response to Hamas terrorism, whichever we call it, in Gaza, but they do frequently refer to things that the IDF has done in the West Bank as a cause of belli, specifically things like destroying terrorist homes after they commit terrorist acts. Are activities like that within the confines of the rights of an occupying power in the West Bank?
So I can't speak to what's going on in West Bank right now, and certainly without any more details than that. I'm sorry.
Do you have another minute to get another question in? Vladimir?
Just unmuting. Hi, hello. Thanks for the great presentation, Captain. I put a question in the chat, and I'm just going to read from it, and you can refer to it as well. You used the word temporary when referring to movement of civilians from northern Gaza to the south. However, northern Gaza housing infrastructure is probably no longer suitable for their return, and the bombing has been so intense that one can hardly make a case for a temporary relocation. How do you respond to the charge that even though the call for relocation was temporary, it was perhaps rather disingenuous from the beginning, given the scale and the scope of intended assault and damage?
Yeah, so I don't think the effects of war that results in the destruction destruction of infrastructure, but like creates a de facto permanent relocation of civilians, right? Because I mean, I think to say that would be to construe the law that anytime you try to keep civilians safe, right, even when you're not forcibly removed from their home or threatening the use of force to remove them from their homes, if X plus Y plus Z and all these perfect factors are met, then haha, you've committed a war crime, when really you were just trying to keep civilians safe. Israel needs the ability to wage war. And the fact that infrastructure gets destroyed and might deprive people of the ability to move back immediately upon cessation of hostilities does not mean that Israel is engaged in the permanent forcible transfer of civilians. In terms of an occupying power, so once Israel does occupy Gaza, if that's what it chooses to do after this conflict, it's going to have an obligation to restore those services. And to that, I would actually look to the Marshall Plan following the Second World War in Germany. I think that would be a good blueprint.
Thank you.
Thank you so much, Captain Wheatley. I just want to say here that our next Matus Law Society event is going to be on November 29th. It's open for Matus Law members only. The topic is Empowering Partnership, the Art of Delegation in Law for Jewish Attorneys. And again, thank you so much for taking the time to be here with us. And
my pleasure.
Thank you everybody for attending. Have a good rest of the day and Shabbat Shalom.